rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. Oh, I thought the other one was going first. I had the order wrong. All right, sorry. Change my way of thinking real quickly. We're here today for oral argument in New Sundance Limited Partnership versus Sean and Shannon Cutler and Lynn Ellsworth and Elaine Ellsworth. This is our case number 1, CA-CV22-0676. Counsel, each of you have 20 minutes for oral argument. Appellant, it's up to you to, if you want to reserve some time for rebuttal, you have to keep track of it yourself. I'd love to be able to say 5 minutes, you're done, but I don't get that power. We have conferenced this case, discussed the matter, reviewed your briefs, and we're relatively, hopefully, familiar with the record, so keep that in mind when you deliver your oral arguments. We will record and live stream this on YouTube, so when you get up, please introduce yourself and tell us who you represent so the throngs watching can keep track of it all. With that, have I covered everything?
Yeah.
Did I forget anything? I feel like I left something out of our little recital. All right, with that, we'll begin. Appellant?
Thank you, Your Honor. May it please the Court, Philip Ruprecht, Fraser, Ryan, Goldberg, and Arnold, on behalf of appellants Lynn Ellsworth, Elaine Ellsworth, Sean Cutler, and Shannon Cutler. I would like to reserve 5 times for rebuttal, so 5 minutes for rebuttal, and I'll try to stick to that. We come to you today having the trial court having granted on a motion for summary judgment relying on in some parts on the wrong legal standard, and second of all resolving questions of fact where there were disputed questions of fact, and finally not, at least as is evident from the minute entry, taking into account that there may have been and there in fact were differences between the facts which would give rise to an easement in favor of the Cutlers as opposed to the Ellsworths.
Before you get into the meat of the factual disputes, tell me if you preserve the argument that there's any differences between the Ellsworths versus the Cutlers easement.
You argue in your briefing that somehow the court missed that they should be treated differently, that they had different claims on the same facts, but did you talk about that below? Did the court have a chance to treat them differently?
It did.
As I read your briefing or your pleadings below, you argued that there was this easement and it applied to both parties. And I never saw a good analysis where you said, here's why you can deny it. If you're going to, not that you would concede it on one of your claims, but if you're going to deny it as them, you should still affirm it as to the Cutlers or the Ellsworths because it's different. I don't see that argument. Can you tell me where it is?
It would be in the response to the motion for summary judgment where the facts or the arguments relating to the Cutlers were followed after the arguments or the facts relating to the Ellsworths. Was it broken out into a separate section? Standing here, I can't remember and recall that it did. I don't believe it did. But it included the facts about the Ellsworths' use and what facts became, it included the facts that were unique to the Cutlers and not just the facts relating to the Ellsworths because they are different. And both the statement of facts and the response to the motion for summary judgment said, here are the facts that relate to the Yeah,
but you presented claims for the group of litigants. You said this is the claim that there is this easement that exists and both of these parties benefit from it.
Yes.
I didn't see anywhere where you said it just may be the Ellsworths here.
Maybe just the Cutlers.
Cutlers, I'm sorry. I'm sorry, I apologize for that. You made a claim that there was an easement.
Yes.
And here were the facts in support of that easement. Some of these are Cutler facts, some of these are Ellsworth facts. But you didn't suggest that that the court should ever analyze these individually.
Your Honor, I can't recall as I stand here what the briefing on the motion for summary judgment how explicit that argument was.
Okay.
And
And I realize there's fine lines on some of these. I'm not saying that, I'm not trying to fault you for it, but usually we try and say, or we say that you got to give the trial court a fair notice as to what the claims are. And it looked to me like you submitted a claim, or the 4 claims that you submitted, or 5 claims below 4 various theories for the easement, but I didn't see a distinction between the parties on those.
Your Honor, the arguments, I don't think it was as explicit perhaps as the court would have liked to have seen.
Well, we can review that.
Yeah, but
I'm sorry, let's get you back to your track.
the facts and the
Tell me,
arguments are there.
because we're familiar with the record and the briefing, and you brought up 4 of the 5 ways that an easement could have been created. What's your best argument? What is the one that is the clearest in your view?
The easement by estoppel.
Tell me why.
Because as to the estoppel, I don't think the facts, I don't know that there are any facts that are really materially disputed. And it is clear from the minute entry that the wrong legal standard was applied in that case.
Does the permission that they gave, that New Dance gave to your clients to use the ranch road to show the property to prospective buyers, does that not break up a chain of permission that is relevant to what was reasonable for them to? I get kind of confused because there's some argument that says, oh, well, they were allowed to say this was reasonable to continue using it based on the permission that was given to them to show this property to prospective buyers, and why wouldn't they have warned them that, oh, but by the way, if you have a prospective buyer, you're not going to be able to use this road anymore. And then there's kind of the argument that ignores that there may or may not have been this permission given. So tell me how I should frame that.
The question of whether permission was given, first of all, is inapplicable to the argument for estoppel. But secondarily, whether permission, the facts on exactly what permission was given to who and when is at best muddled, because none of the defendants, my clients, testified that they were given explicitly permission to do certain things. Mr. Mason says, well, I gave somebody, clearly David Decker, non-party here, permission to do certain things on the property, and he presumes that that was also permission given to the Ellsworths. The elements of the estoppel, though, come from restatement section 2.1 of the restatement, and they don't require a promise, because the restatement says, look, if you have a promise, then we analyze whether you have an easement, an oral easement, and that's different than conduct,
right,
or lack of action, in this case more particularly. And I think that's part of what makes the case of the analysis here more difficult and a little confusing, because it is really...
But the easement requires that the landowner permitted another to use.
Yes.
Okay, permission, isn't that... you said it doesn't require a promise. I guess not necessarily a promise, but it requires some affirmative act permitting someone to use this. So what are you arguing then?
I would submit, Your Honor, it also an act would be cleaner, but inaction suffices. In this case, there's no dispute.
Then how is an easement different, an easement by estoppel different than adverse possession and or the 10-year easement?
Because under prescriptive easement, it has to be hostile. And in this case, and for an easement by estoppel, it doesn't have to be hostile.
Okay.
All an easement by estoppel requires is that they were allowed to use the property. And as to that, there's no dispute that for the Deckers, the Smiths, the Ellsworths all said this is the road we use to get to our property, and this is the only road we ever use to get to our property. And And the gate was never locked. There were no trespassing signs, so we used it.
Yeah, but
And nobody ever,
So either he permitted it, which puts it into, by affirmative act, he permitted, he said, hey, you guys can use this to sell the property, and then we're in easement by estoppel, or he didn't say anything, which is what you said a minute ago, well, just letting them. But then that becomes adverse possession. That becomes the 10-year requirement.
I would submit it supports both.
Okay, but if he's doing nothing, then you're just doing it without his permission. That's hostility. Well, hostility sounds like do you understand where the disconnect I'm finding here?
I think the same conduct can support an element for estoppel and for prescription.
So we just throw out the 10-year requirement?
No, we don't throw out the 10, well, under certain circumstances, yes.
And what are those circumstances?
That if it was...
I would submit to you that the circumstances are when you have permission.
And
That's when you're permitted to use it and you have reason to believe that you can continue to use it.
the easement by estoppel simply requires that the use occurred under circumstances under which it was
No,
reasonable.
that you were permitted to use it and there were circumstances that were reasonable to believe that permission would continue.
That...
I can read from the restatement if you like.
The landowner permitted another to use
Yes,
that land under
yes,
circumstances in
yes.
which it was reasonable to foresee that the user would substantially change position, believing that the permission would not be revoked.
Yes.
So it's all about permission.
Yes, it is.
So you take out that, you back off that argument now that doing nothing is enough?
Yes.
Okay, so
Excuse
now
me,
we can go
sorry.
on.
No, I would not back off that argument. I would argue that allowing somebody to do it, knowing that they're using the property, can be found to be permission. So even if there isn't a conversation...
And what's your case for that?
Basically, the restatement, Your Honor.
Or there's commentary that says that? Because we found cases that says it's affirmative permission. It is permission. It is a promise. It is a statement. I couldn't find any that said what you're saying, which is the 10-year rule goes right out the window if you just allow someone to do it.
Well, illustration 5 from the restatement, which is cited in the brief.
Can you read it to me?
Well, it's a little long. The owner of Black Acre, knew that White Acre, an adjacent improved property, was landlocked, and that its owner had been using the road for occasional access. When A built a house on White Acre using the road to bring in construction materials, and then graded and paved the road to provide a driveway to the house, O said nothing about his right to revoke A's permission to use the road.
Is there an Arizona case that's applied that one?
I did not find one.
Okay.
What about prong 3 of easement by estoppel that says an injustice can only be avoided by the establishment of the easement? And I think that goes into other questions we have about Lot 17, what's happening now, the idea of whether we are looking at the options that they had on Lot 17 before they sold it. But easement by estoppel says there has to be an injustice. And in this case, if they could still use 17, if they could have used 17, is that something we have to look at to evaluate whether there's a true injustice if your clients are not granted an easement by estoppel?
I think it's something at a trial, the court can look at.
But if the factual record at the motion for summary judgment stage, there weren't any factual disputes about the nature of the sale and what they'd been using, and could a judge not have entered summary judgment on injustice by the factual record that you presented at the trial court?
I don't believe so, no, because what is injustice is a highly factual inquiry.
Well, if they have another route that they could use, then I would say that's a big step towards not being an injustice that they can't use Appellee's land to access their property.
And after hearing all the facts, maybe the court would, a trier of fact.
Well, there wasn't dispute, was there, about the order of the sales and what your clients held on to as far as Lot 17 and how long they held on to it, and that they, in fact, gave an easement to the Aztec grazing people at some point. So, I mean, there wasn't a lot of factual dispute about the order of things.
There was not.
Okay.
there was not.
And could the court have rightly made a determination at summary judgment that there were no material facts in dispute as to whether there was an injustice?
No, it could not. Because even having some alternative route, some other way to get there, does not preclude a finding that it would be an injustice to deny my clients this particular route. It is certainly a factor, but it is not an outcome determinative factor. So if they had other ways to get there that were, simple and uncomplicated, yeah, then that would be a very difficult factor to overcome. But in this case, the court starts off with a conclusion that there's an alternative route, even though there are issues and questions about whether that's really true or not. So what's an injustice? I submit it's, even if there aren't disputes about who got what when and who acquired what property when, the question of whether it was an injustice is ultimately a trier of fact issue.
How did your client, staying on prescription, how did your client, or estoppel, I'm sorry, how did your client change their position in reliance on this permission?
They built 2 houses, they acquired more land, and they acquired more land. So they believed they had access. They built, first the Ellsworths built their house, and then the Cutlers came along, and after 5 years...
Is it access, because I understand the access argument, and this kind of moves to some of the others, or the other necessity arguments, but is it just access to that road, what is it, 270 below?
77.
77 below?
Yes.
Or is it something more that access really is determinative? Or where access becomes determinative? It's not like there's a whole bunch of adjoining properties.
Yes.
And just because you can't take the straight route down to 77 doesn't mean you can go this way or that way or get there some other way. Why does the access have to be on the ranch road?
Because there's no access on any other road. In other words, the property immediately to the to the west is, for the entirety of the section, is property that is owned by Aztec, actually.
But was owned by your clients?
No, not the property to the west.
I'm sorry.
The property to the east.
But to the west of the road was owned by your client?
Yes.
Okay.
Yes.
But to the east, why, just curiosity, why did your client, when he applied for his building permit, say that what we're calling the Aztec easement on number 17 was his route to his property?
I don't know, Your Honor. That showed up in the building permit file.
Well, it didn't just show up, it was put there by your client, apparently.
According to Mr. Call, yes. Apparently, my client brought it in and said, I think this is the easement. I don't have a good answer to how that showed up in that file.
Okay, but for all intents and purposes, the city thought that they didn't need to worry about any ranch roads and a property owner such as appellee could look at that building permit if they had chosen to and say, oh, well, I don't have to worry about the ranch road that I see people using because really the route that he's using to get to his property is the Aztec easement. I mean, you put a lot of pressure on Mr. Mason to have found the house built over the hill and to not be someone who doesn't pay attention to who's on his property, and you put a lot of weight on what he should have been doing, although I don't see that the case law says that you can't be an out-of-town owner who doesn't know what's going on. But even if he had looked at how is he getting there, it looks landlocked to me, he would see that, well, he's using the Aztec easement. Why would I worry about that he's landlocked or that the new impressions I'm seeing on my ranch road are his?
Well, whether Mr. Mason thought that, there's no evidence of the record Mr. Mason ever thought that road was on somebody else's property.
What road?
The roadway that's there. The Aztec,
the ranch road?
Yeah, the ranch road.
But my question was, public record says that he's using something that's on lot 17 to get to his property, your client. That's what the building permit says, is that he's using the Aztec easement.
Well, the building permit doesn't say, doesn't speak to that issue. It doesn't speak to which road is being used.
Are you sure?
It says I have access to my road via the Aztec easement.
And there's no road there. There is no road on where that
So
Aztec
whether he
easement
has
is.
a road or a point of access, I'm not sure that we're getting that granular. If he's got access to his property through the Aztec easement, who cares if there's a road? If he wants to drive off-road every time he accesses his house, why would New Sundance care?
They wouldn't care, but he doesn't have access. He did not have, at that time, access along that easement. There was no road, Ray, that easement contained a legal description, but there was no actual road there.
Counsel, if you want to reserve a minute.
I would like to, thank you.
See, I say I'm not going to remind you, but then I can't help myself sometimes. Counsel for appellee?
Thank you, Your Honor. Looks like I'm a bit shorter. Do I need to move that, or does it?
I can hear you. I don't know if all the throngs on YouTube will be able to
Yeah,
follow.
I'm sure. I don't even think my husband.
I looked
can
up one
use
of
it.
these, and I think it was like 6 months after an argument. I thought that was a really interesting case, and I went back and looked, and I think we had 4 views. I was the 5th view. myself, so.
Yeah, it's the attorneys and their law partners. Your Honors, good morning. I apologize. Isabel Humphrey, Hunter Humphrey and Yavitz, on behalf of the appellees, New Sundance Limited Partnership, and the Bear Ridge Resort, LLC. I was glad to hear Mr. Ruprecht change his verb tense from "there is no road on Section 17 and there is no easement on Section 17" to "there was no road and there was no easement on Section 17," because his clients do currently have an easement over Section 17, that Aztec easement that they used to not have rights over, they now do have the rights.
Is that in
over.
our record? Didn't that happen after this was resolved?
It did happen after. I did drop a footnote to let you know that change had happened, and
But why that? I noticed your footnote, and
Yes.
I thought that's almost. I don't know. I didn't like it because we have to review our record based upon what was on the record at the time of trial. So I don't know why I should care one whit about that.
I think the only thing that concerns me about it, Your Honors, I don't like to have any statements that there is no easement, there is no road, and I wouldn't want that
I
to be.
won't chastise you for pointing to stuff outside the record, but I would encourage you not to reference it anymore.
I understand, Your Honor. I wouldn't want that to be in any opinion, just because it would be a misstatement of the current situation. Your Honors, I put a map of the sections at issue on page 5 of the answering brief, just in case we need to refer to that at any time. You guys are the last ones, I guess the appellate courts are the last ones to get any kind of technology in the courtroom, so we can't draw on things and show you where things are, but I'll do my best to
You can hold
be.
stuff up and point. if you want
Exactly.
to.
I'll do my best to be clear in my speech. Here we had, as you pointed out, Judge Morse, there were 5 easement claims that were made. There was one that was dropped at the summary judgment stage. And it's a little bit confusing because they have overlapping elements but different elements to some degree. But I wanted to spend my time today, in addition to answering any questions you have, to point out that all these claims can be resolved by recognizing just a few undisputed facts. And there really are an incredible number of undisputed facts in this case compared to most of the easement cases that I've handled. It's a pretty extensive undisputed fact list, and it's page 4 to 12 of the answering brief, just to show you how extensive it is. First of all, very important fact that that the Ellsworth's and Cutler's land, the appellant's land, was not landlocked at all until they sold Section 17. Their Section 18 land was not landlocked until they sold Section 17 to Langley Reflections. And when they sold Section 17 to Langley Reflections, that's when, as of what was shown in the public record, they had no access to their land. Now, Mr. Ellsworth managed to get a building permit, as you pointed out, by telling the building department that he had an access over Section 17, but he did not, as his counsel has acknowledged. So when that land was sold to Langley Reflections, and it created, that severance created the landlock, there comes into being, by implication of the common law, an implied way of necessity for the Ellsworths. At the time, the Cutlers weren't involved, but for the Ellsworths to get to their land over Section 17, the land that they've just sold, and created a landlocked situation. This is very similar to the fact pattern in the Tobias versus Daly case, 2000 Court of Appeals. I'm pretty familiar with that case because it was my first appellate court loss in the year 2000. So I remember it. And in that case, my clients, Tobias family and the Flynn family, they were required, because a common law implied way of necessity had come into effect upon the severance of parcels when the parcel that they later bought was landlocked. They were required to go through a 10-year process of getting roadway permission to build a 4-mile road through the national forest to get to their land, rather than taking a driveway that went directly to their property past other residential properties in Oak Creek Canyon area. So that case is a good one to look at to understand why when you have landlocked yourself by selling
You can't claim necessity on the most convenient neighbor.
Right. You can't just pick another neighbor and say, well, justice requires you to give me a road. Well, you landlocked yourself by selling this land to somebody else. Now, maybe the fair thing is to say you landlocked yourself, you're out of luck. But in Arizona, the public policy is we try not to have land that is landlocked forever. We try to have some way for you to have a route to your land. And in this case, the way is you have a common law implied way of necessity. You impliedly retained an easement to get over that land that you sold and landlocked yourself so that you can get to your property. And it saves you from your own contractual error.
Counsel, we focused on the estoppel arguments, and so I kind of want to go back there. What do you make of Mr. Ruprecht's argument that there are factual issues about what constitutes injustice?
Well, I think, first of all, you don't have to get that far as to the prong about injustice. There are prongs before that. Looking at the...
Okay, so let's start with permission then.
Yeah, I mean...
There's no factual question about whether or not there was permission.
There's no factual question about whether or not there was a promise or representation via conduct to the Ellsworths or Cutlers that would justify their reliance to think that they could use that road forever. There was, as Mr. Ruprecht pointed out, according to his clients, the only person who was given any kind of permission was David Decker, who previously owned some of this Ellsworth Cutler land, but no longer does.
He was trying to sell it, but presumably to sell, you have to access the property. Is that not so?
Yes, and there's a distinction, and I'll just refer you to this point in the record so you can look at it yourselves, but IR, Index Record 58, pages 80 to 82, is Mr. Mason's deposition where he's attempting to explain the idea was that the Deckers and the Ellsworths, who were both real estate brokers, and Mr. Mason, they were all real estate brokers, the Deckers and the Ellsworths were going to try to sell all of Section 18. They were going to try to sell the whole thing to a single buyer. So they needed to access all of Section 18 to sell it to the buyer. Mr. Mason had no, and this is an undisputed fact, he had no idea that they didn't have some other access to their property. they had given him a map showing roads going right to the property, showing this easement on the side of Section 17 that didn't say, that's not our easement, by the way, that's somebody else's easement. So they had shown him these maps showing an easement, showing roads, he never imagined that they didn't have access to their property. So he's not giving permission to Mr. Decker to come on the property to show buyers because he thinks they don't have access. He's giving permission because Decker is going to try to sell all of Section 18. And so Mason says, of course you can come on my part.
But isn't whether or not that representation constitutes permission to the estoppel, easement by estoppel requires a permission, right? And Mr. Ruprecht submits that doing nothing to stop someone from entering constitutes permission. So.
And I think that's clearly incorrect. I mean, I think it sounds like your honors have done some research, looked at some of the restatement and that sort of thing.
Obviously not at the illustration, because I was surprised by that illustration. So can you respond to it?
Yes, absolutely. And I responded to that at pages 18 to 19 of my answering brief. And I say there's this illustration in the restatement of a landlord who, first of all, knew his neighbor was landlocked. Here it is undisputed that Mr. Mason did not know that they were landlocked and had been given maps that seemed to show plenty of access to their land. Second, in this illustration, that the landowner knew his neighbor was using the road for access. Undisputed. Mr. Mason did not know this.
Even after the grading and the paving?
That's when he started objecting. How
long after the grading did he object?
Because that happens in like 12 to 14, right?
Yeah.
Yeah, the grading happened in 12 to 14.
I thought the demand letter didn't go out till 19.
Right. The lawsuit wasn't filed till 19. The demand letter by the Ellsworths and Cutlers didn't go out till 19. I think in this record, because we were trying to limit it to the things that were clearly undisputed, we did not include, there's some disputed facts about who's objecting when prior to 2019. So for purposes of this record, let's call it 2019.
Okay.
That the objections are in the record.
But your main point in response to illustration 5 is that it's different because his client had said, I've got other access via the easement, and your client had seen maps that showed other roads.
And,
so this wasn't a case where a party knew that the land or the neighbor was landlocked and therefore acquiesced in letting them build a road.
And I think, quite frankly, that illustration makes very little sense to me in any event. I think it's more of an adverse possession situation. And, we all know what the word estoppel means. You have to do something that causes you to be estopped. That's what estoppel means. And
has any court in Arizona actually adopted that section of the restatement, not just the illustration, but that section?
I have not found it, Your Honor. What I've
we
said
have the
is
general statement that we filed a restatement as long as it's consistent with Arizona law and in the absence of other authority. But there's lots of Arizona authority that says that lots. I hate it when counsel uses loose terms, so I will myself for using that. There is Arizona authority that suggests that we don't substitute estoppel for the allowance. In order to meet an easement by prescription, you have to do it notoriously and openly for 10 years, and then you can have your easement, right?
Exactly, and that's what I was going to say, Your Honor, is that I believe that Arizona...
You may have an unjust enrichment claim for the value of letting someone build a nice driveway up your property, but that doesn't mean that they have rights to it, right?
Exactly, and I think that, what would be consistent with Arizona law would be to apply an easement by estoppel, just the way we apply estoppel in all sorts of other, quasi-contract situations. But to substitute, to interpret the restatement in such a way that an easement by estoppel is just a shorter way to get adverse possession, I don't think that's consistent with Arizona law. And I don't think it makes any sense. I think the only other...
So let's circle back to injustice, since we started there with the permission.
I do have some things to say about that.
Do you make room for the possibility that there can exist injustice even if landlocking is not part of it?
There can exist injustice.
So,
No,
for example, you
Yeah.
were talking about your experience with the Tobias case
Right.
earlier, and your suggestion was, in how you related it, that it was somewhat onerous to your
Yes.
clients to have to do this rigmarole with the National Forest Service to do a great big workaround when there was a very simple
Right. And
alternative. So is that not injustice, and would this not be injustice? I mean, I think that's what Mr. Ruprecht's argument
I think it's
really was.
clearly not injustice in this case, Your Honor. And again, there's other elements in count 3, and I don't want to suggest that there's not. And the injustice element only applies to count 3 as well. In this case, you have petitioners who have either voluntarily landlocked themselves. There's a reference in the Dabrowski case, which I cited, that talks about if you voluntarily landlocked yourself, you're out of luck, essentially. If you really did it on purpose, if you just voluntarily landlocked yourself. They either voluntarily landlocked themselves or they negligently landlocked themselves, in which case they ought to be, it's not unjust to ask them to get their common law implied access, which is right over the section line from the road they want to use. And the other thing that makes it somewhat unjust, Your Honor, to ask my client to let them use their side of the section line is that the Ellsworths sneakily, once they found out, Mrs. Ellsworth explained this very nicely in her deposition, once they found out that this roadway that they like to use, I guess, was partly on the land that they had sold, Section 17, they moved it, quote unquote. They moved it so it was on my client's land instead. So they could use my client's land instead of the land that they sold to Langley Reflections.
And I hear what you're saying, but I believe Mr. Ruprecht's argument is, isn't this a matter for factual resolution by the Superior Court? Because we're here on summary judgment.
Right. All of these things that I mentioned are undisputed facts.
Well, I understand that, but the import of the fact is really kind of what we're talking about, right?
Right.
So doesn't that require us to do some weighing?
If you were to reach that element, which I would not suggest that you need to, I don't think it requires any weighing to determine if it's unjust, because I think as a matter of law, the law has determined that if you have a common law implied way of necessity, it's unjust to take your neighbor's land instead. It's not part of the law because it's not just. The justice is you used the land that you just sold if you made a mistake and you didn't retain your easement as you should have. Your Honor, and I reference this to some degree, but one of the other important facts in this case is that fact that the ranch road that we're talking about here that is now entirely over Section 18 was previously half on Section 18, and then it crossed over and went on Section 17 before it crossed back over to the Ellsworth Cutler properties. And so as you're going through the elements of the different easement claims, for example, in count 1, easement by prior use, which the Dabrowski case called implied easement of necessity, at the time of severance of the properties involved in this case, was there a long continued and obvious use of the proposed access route? Well, the time of severance of the properties involved in this case is 1998. That road didn't go through to the Ellsworth properties until at least the very end of 2012. And so as of 1998, can they establish a long continued and obvious use of this roadway to get to their property from the freeway? No. if they were using it back then, they were only using it to get up to the railroad tracks, and then they had to go over onto the other property in order to get up to their land. I have 43 seconds left. I'd like to know if anybody has any burning questions. Okay.
No. Thank you, counsel.
You're welcome. I appreciate the time. Thank you.
Well, I will avoid trying to do a FedEx commercial here in the 1 minute I have left. Two points. First of all, even the Tobias case says that in weighing the equities, the court was supposed to weigh the equities about what is unjust, what's essential, what's fair, and that even if there is an alternative means of access, that doesn't bar the court finding an easement either by prescription or by estoppel. It's simply one of the factors. The other
they
issue,
say if it's unreasonable or inadequate. It's not just whether there's an alternate route, which is part of the problem for you, right?
yes, but ultimately it's a question of trier fact weighing what is essential, what is necessary, what is justice, and that didn't happen here. I'll use my final 7 seconds to say I wanted to talk about the prior use, but I've run out of time because I think that's a good argument as well.
Thank you very much, counsel. We appreciate both of your presentations today. We will take this matter under advisement and issue a written decision in due course. We are in recess.